we'll have now our second speaker, Mr. Olivier Branger, the head of unit at the European Commission in charge of the Next Generation Internet Initiative and Internet Governance Policy. Before working on NGI, Oliver was executive assistant to the Director General of DG Connect. Before that, he held various positions in the European Commission, dealing with policy development and implementation in the area of cybersecurity, telecom regulation, and competition law. Prior to joining the Commission, Oliver worked as a consultant in the field of telecom. He is an engineer by training. Oliver, you have the floor.
Thank you very much, Delia. Yes, I think I feel a bit alone in this panel. I think I'm the only non-lawyer. The other four are lawyers. I also feel like I'm the bad pupil because I did not prepare slides, but I come directly from the meeting of ICANN in Marrakesh. So I traveled a long distance. I decreased the temperature to be able to present to you the perspective of the European Commission on this whole WHOIS reform process. First, I'd like to start with a few facts, and I would like to correct you, Alex, on one thing, only one. WHOIS actually is not a database. WHOIS is a query protocol. So it's a protocol that allows to get information about registrants behind the domain names. And it provides also a number of related services. Initially, WHOIS was used by the engineers to be able to contact each other when there was a problem on the domain name. Engineer A could contact an engineer B to solve the problem. And then with the time, it became a tool for various purposes, and Alex mentioned several of them, for law enforcement authorities, for IPR enforcers, for cybersecurity experts, to track wrongdoers, to get information about websites. Another fact is that there is no centralized WHOIS database. So in fact, the data about the registrants is stored and managed by the contracted parties, that is the registries and the registrars. So ICANN is not managing a central database. It is the registries and registrars who are managing a database with registrants' information. And ICANN manages the system through contracts. So it has contracts, and this is why we call them the contracted parties. Another fact, I think, is that GDPR did not create a new situation. I mean, there have been in Europe data protection rules for more than 20 years, which had more or less the same principles as GDPR. And for more than, well, not more, but for approximately 15 years, the European data protection authorities have been pestering ICANN to adapt the WHOIS database to protect better the personal data contained in the WHOIS database with no effect, or very little effect. So the issue is not new. The issue of protecting personal data, the issue of having more accurate data in the WHOIS database is not new, but no action had been taken before GDPR entered into application. And you can imagine why GDPR made a difference. It's basically because there are fines at the end of the game. The other point I would like to make is that, as Alex said, ICANN is a not-for-profit organization, and it functions according to the multi-stakeholder model. So it means that for every policy, every rule that is developed in ICANN to manage the domain name system, there is a dialogue, there is a discussion with all parts of the communities to agree on these rules and these policies. So it means you have to put together the registries, the registrars, you have to put the business community, the civil society, the governments, and you have to agree, you have to come to a consensus. So of course the process takes time, but at the end of the process you have a product which is very solid because it has been agreed by everyone in the community. Now the WHOIS issue, in May 2018, 25th of May, GDPR entered into force. ICANN took a decision, it is their decision, they decided to redact all personal data from WHOIS. This is a maximalist approach. And of course, they chose this maximalist approach because they wanted to reduce the legal risk for themselves and for their contracted parties. But it could have been done otherwise. If work had been done before, well before the 25th of May date, we could have had a WHOIS access model. But we are doing this work now after this date of May 2018. So what is the issue? The issue is that there are a number of entities who need access to WHOIS data. So the law enforcement authorities, the IPR enforcers, cybersecurity experts need access to this data to be able to track, find wrongdoers on the internet. This is because it is surprising. I mean, I discovered that when I started to work on this file, but the wrongdoers are not, you know, they are humans. They are making mistakes. Or they are doing things in a simple way. So very often they will use the same, more or less the same email when they launch a website from where they will conduct abuse. They might use the same contact details. And this is how law enforcement authorities, for example, manage to track these wrongdoers to be able to find them in case an abuse has been committed, but also to anticipate, so to be able to see that behavior is being done and it corresponds to something that has already been done, and you can prevent it. So at this point in time, because as Alex explained, now with these temporary specifications, the contracted parties, the registries and the registrars, have to provide access, have to reply to reasonable requests for access. The access seekers are faced with hundreds and thousands of procedures to get access to the data. So that's very cumbersome, and in the end, it really deprives them from important information. So they are still using old databases, but of course, as time passes, these databases are less and less accurate. So this is the issue. ICANN decide to retrieve all the information, and it has an impact on those who are using this information to keep the internet safe, secure, and avoid abuses. Now, there is, to reply to that, there is the WHOIS policy reform process. So this EPDP, Expedite Policy Development Process, has been launched in June last year. It's multi-stakeholder, so you have all the communities represented. It's really heavy work. So I have someone in my team who is spending, so we are represented as a part of 3 government representatives in this EPDP, and it's really heavy work. It's 1 or 2 conference calls per week. It's intersessional work, so it's nearly, in our case, it's nearly a full-time equivalent to participate in this. And it's consensus-based. So every step you make, you have to agree with all the parties. I will not go into the detail of the phase 1 report. So the EPDP went through a number of initial questions. In particular, they discussed and they decided on a list of purposes, because the basis of GDPR is that you need to have a purpose for processing data. So they agreed on the purpose for processing WHOIS data. Now they are in the phase 2. They have a new chair who is a seasoned ambassador, Latvian ambassador, who is doing a very good job. And I think the key work they are going to do now is to develop this standardized access model, in which they will have to define how access seekers can be accredited, how access seekers can be authenticated, what are the processing activities that are involved in disclosure of personal information, what is the legal basis, or what are the legal bases to do that. So that is really very specific, very down-to-earth work that they need to do now and that they are starting to do at the moment. From the issues which have been deferred from phase 1, there are a number of which are interesting. Indeed, as Alex mentioned, the distinction between legal and natural person, if you should do them. In our view, in the European Commission, we made it several times, the GDPR applies only to natural person. It does not apply to legal person. So the policy should not apply to legal person. They are working on also another very important issue deferred from phase 1, which is data accuracy. This is a requirement of GDPR. The personal data that you store, that you process, have to be accurate. And today it is not the case. The data are not necessarily accurate. So the work is ongoing. There will be a new report of this phase 2 for the next meeting of ICANN in Montreal in November. And they hope to close the phase 2 by spring next year. Parallel to this policy development process, there is implementation work ongoing, so that's very good. I mean, ICANN is working both on the policy development and the implementation already. And the idea is that the new policy should be implemented by February next year, but most probably it will not be the case because it will take time to do all what is needed to do implementation. So I think if we have a policy in place and implemented in 2020, it would be a very good result. And in terms of the usual ICANN process, it would be also a short period of time. Policy development process usually takes several years. So what is our, and then last point, yes, in parallel to that, ICANN, so the organization, the team of ICANN, is working on a model where, a centralized model, where they would take responsibilities for several aspects of the unified access model, authentication, accreditation, access. And they will be discussing shortly with data protection authorities to see how they can build such a model in a way that is compliant with GDPR and that allows also to move the responsibilities from the contracted parties to ICANN, the organization. So there is work ongoing at the moment in that, and there will be dialogue. There have been already a number of meetings with the data protection authorities who have been really helping the process. So the European Union position, first it's a European Union position, so it's not only the European Commission. We have had discussion in the Council, and we have agreed on lines to take, which are binding on the member states. They are available. Maybe I will be able to share the link with them, so you can see what is the position that we defend in ICANN. Our line has been extremely constant, so we fully recognize the role of ICANN in ensuring the security, the stability, and the resilience of the DNS. And as part of that, we ask ICANN to ensure a functioning WHOIS service, including the collection, the retention, and the publication of accurate information on domain names and registrants. And this should be done in full respect, of course, of data protection rules. We have always pushed for a speedy policy development process, so to arrive at a model, at a new policy, a new access model, as quickly as possible. We have made clear that the current situation, which is where there is very fragmented access to the information, is not satisfactory, and a proper unified access model is needed. We have also explained different criteria to ensure GDPR compliance, like the need to have purpose definition, the need to have transparency towards the end users about how their data is being used, the need to have accuracy of data, or to have limited period for the retention of data. Our views are very well reflected inside the Government Advisory Committee of ICANN. So it's the committee where all 170 or 80 governments are gathered to advise the ICANN board. So the views of the European Union are very well reflected in the communiqué of this committee, of the GAC, if you read them. And the last point I wanted to mention is that we are also working at the moment on setting up a list of public and private entities that have a legitimate interest to access non-public WHOIS data. Because we think that with this list, it would already help the registries and registrars, they would see that someone who is in an entity who is in this list has a reason to seek for access to personal WHOIS data. So we think that if we keep the current pace, if the different parts of the community maintain a good constructive spirit, it should be possible to have a new policy developed and implemented in the course of 2020. It remains ambitious, but we think it is possible. Again, I want to restate that GDPR has not created this issue. The issue has been there for 20 years. It has not been tackled, and it led to the current situation. The final solution for access to WHOIS will be more complicated than was the case when there was open access. That is for sure. I mean, even a very effective unified access model will be more complicated than having all the data retrievable by anyone on the internet. But the protection of personal data, I mean, it's a fundamental right, and it's important to abide by it. It has advantages. There is less spam, so these email addresses and information were used to do spamming. There is less risk of cyber attacks, such as identity theft, so there are a number of advantages. Also, GDPR brings benefits like the transparency for the users, so now the users are informed that their data are collected and for what they are used. I mean, some of you, like me, might have discovered one day, it was 10 years ago, that all my personal data were on the internet. I was not aware of it, and I was really unhappy about it. I'm sure there are many users who were in the same mood. And then it brings other benefits, GDPR, like I mentioned, accuracy of data, security, etc. So I think it is possible to reconcile the different public policy purposes, data protection, but also tackling cybercrime and abuses on the internet, IPR infringement, cybersecurity. But it will need a lot of work and a lot of cooperation between the communities. It's very important to have cooperation, cooperative attitude, and for example, even if the business community did not vote the phase 1 report, at least they did not oppose, and that is a conciliatory approach. This is really what we need. We need to arrive at a consensus. Everyone needs to make an effort, and in that case, for the phase 1 report, it was the business community who made the effort for the process to go forward. The Commission and the data protection authorities will have played their parts, and they will continue to play their parts to arrive at a balanced model. Of course, we, the Commission, we are not in charge of implementing GDPR. It is the data protection authorities. So we can help, we can explain GDPR, we can contribute to the policy development process. But in the end, it is the data protection authorities who will have to say, okay, if the model is correct or incorrect, and what needs to be changed. But this dialogue is taking place. And the final point I would make is that really this is a test case for the multi-stakeholder model. So this is a true public policy issue. You have to balance between different public policy interests, data protection, cybersecurity, protection of intellectual property, and you have to make that choice. So the question is whether the community will be able to solve it. And as you know, there is a debate at the moment on the future of internet governance. You might have seen that the UN Secretary General asked a group of experts to come up with a report. It's the report of the high-level panel on digital cooperation, and it is discussing exactly that. It is discussing how we can better cooperate on the internet to make it a safe place. And one of the models that is promoted by this high-level panel is called co-governance, and it is very close to what ICANN is doing. It is inspired largely by the model of ICANN. So I think this is an opportunity for ICANN to show that the model works and it delivers. And personally, I am confident that it will deliver. Thanks a lot.
Thank you very much, Olivier.